very warm welcome to the second lesson of our lesson series on the law of evidence. In today's video, we will talk about the law of evidence as being a law of procedure. Let's get into the lesson. Laws can be divided into two broad categories. The first being that of substantive law, the second procedural law. I'll talk a bit about substantive law first. You see, substantive law means that it contains some substance. Now, what is that substance? Well, the substance means that it determines the rights and the liabilities of the persons affected by that law. Let me give you an example. If I talk of the law of crimes, right, or the law of crime, in that, if I talk about the Indian Penal Code, the IPC 1860, then you will find that various provisions in the IPC tell you as to what the name of the offence is, it tells you as to what the ingredients of the offence is, and then you are told as to what the punishment is. In other words, it determines as to what the liability would be, right? Now, when I talk of the procedural law relating to the law of crimes, then I have to talk about the CRPC, the Code of Criminal Procedure. What it tells you is that as to how the IPC and other substantive provisions relating to crime have to be implemented. It tells you as to how the law has to be implemented. On the other hand, substantive law tells you as to what the law is. Of course, it is not possible to completely categorize a law as being completely substantive or completely procedural, but then we must understand this demarcation. Substantive law, most simply stated, gives you the end, right? It gives you the end. And the procedural law gives you the means, right? So you can think of substantive law as the destination, and you can think of procedural law as the journey or as the route which is specified to achieve that end. Talking about substantive law operates prospectively. What that means is that the substantive law operates in the future, de futuro. What that means is, I just said this is a little Latin for it. What that basically means that it operates in the future. What that essentially means is, let us say a person commits an offense on 31st December 2019, okay? And a law is enacted on the 1st of January 2020. You have the law to punish it. Now, is this law applicable to this offense? The answer is no, because it is only applicable for offenses committed after the date of enactment. Okay, that's what we mean by prospective operation. There's another thing about prospective operation. Let us say the offense was punishable as of the 31st of December 2019, but it was punishable with, say, 5 years. On the 1st of January 2020, the maximum punishment for that is increased to 10 years. So earlier it was 5 years maximum punishment, now it is 10 years. If a person commits an act on 31st of December 2019, and as you know, trials take a long time, so his trial is continuing into 2020. Let us say it is now the 1st of May 2020, his trial is still happening. Is it possible for him to be sentenced up to 10 years? The answer to this also is no. He cannot be sentenced to a punishment that exceeds what the maximum punishment was at the time when he committed it, which means that these substantive laws operate only in the future, they operate prospectively. There's one more thing that you need to know about the prospective operation of law. So this was something that I told you, which you can find in Article 20 of the Constitution. Article 20 of the Constitution, more specifically Article 20 subclause 1, which talks about ex post facto laws. That basically is the principle that I explained to you, that you cannot have a retrospective operation of the laws. The operation will always be prospective in the future. There is another place where you can see the law relating to the prospective operation of the laws, and that comes from the leading case of I.C. Golaknath, the 1967 case. Alright, you can Google this, make sure you research this. It's a very important case in the constitutional history of India, wherein it was wherein the doctrine of prospective overruling, the doctrine of prospective overruling was laid down. So what that said was that if there is a ruling of the court, then that will again operate only in the future. It will not operate so as to change the past. So we've understood the concept of prospective operation as far as substantive law is concerned. This is why it is important. This is significant because substantive laws operate prospectively, but procedural laws can also operate retrospectively. Now, another way of referring to retrospective operation is to call it retroactive. It's one and the same, whether you say retrospective or retroactive, it's the same thing. Now, what is the meaning of this? It means that, let us say there's a certain document, let's say a contract, was executed on, let's say the 31st of December 2019. Okay. Now, as of 31st of December 2019, let us say there was no need for a witness. Just giving you an example, don't worry. Suppose there was no need for a witness. And then what happens is that on 1st of January 2020, the law of evidence changes. It says that you need 2 witnesses. Okay. Now let us say the dispute comes before the court, and let's say it comes before the court in 2021, or the trial is extending up to 2021. Now, will this new law operate for this document? The answer is yes. It will operate even in the past. Why? Because the law of evidence is a law of procedure. The law of evidence is a law of procedure. I've used the word adjective law here because the word adjective law is synonymous with procedural law. There are some jurists who believe that an adjective law is a part of procedural law, whereas some jurists say that adjective law is the same as procedural law. For the ease of our understanding, we could perhaps understand that an adjective law is a synonym for procedural law, right? So the important point that I want to establish here was that procedural laws operate retrospectively, whereas substantive laws only operate prospectively. You may have heard that procedural law is regarded as lex fori. What that means is that it is the law of the forum. Lex fori is a Latin phrase and it translates as law of the forum. Now, what is this forum? The forum refers to the court, and the court is in India. Just keep this with you. I want to juxtapose this with another point, which is about substantive law. Now, substantive law is often referred to as lex Quasi. Okay, I'll come to these now. You see, let us say there is a dispute between a foreigner and an Indian, or between a foreigner one from say Germany with another foreigner say from France, so foreigner 1 and foreigner 2. Let us say we have this dispute between them. Now, as far as the applicability of Indian law is concerned, the rules are a little different for the laws of procedure and the laws of substance. Okay, so when I say that a procedural law is lex fori and the law of the forum, and the forum is the court and the court is in India, we know that the Indian Evidence Act is a procedural law, and therefore the Indian Evidence Act and the law of evidence in India is lex fori. It means that for this dispute, the law of evidence that will apply would be the Indian law of evidence. Why? Because procedural law is lex fori, which means that, let us say, if you are fighting your battle in this court, okay, you're fighting your battle in this court. That's a bad diagram of a court, but let's just assume that this is a court. So let us say you're fighting your battle in this court. The law of evidence that will apply will be the law that has been followed by this court, because this court is in India. That's a bad map of India, but I hope you get the point. Okay. On the other hand, when I talk of substantive law is not always the law of the forum. On the contrary, sometimes in the application of substantive law, you might have to use foreign law. And we have to then see as to what the relationship between the foreign law and the Indian law is. In other words, as far as the substantive matter is concerned, we consider foreign law, which means, let us say, there was a contract here, or there was a marriage, there was a divorce, there was an offense. Now, all of these things, what has actually happened, the rights and the liabilities, who gets the child, who has the property according to the contract, what is the punishment for the offense, the what, the substantive part of it, might be sometimes influenced by foreign law, but the how are you to prove your facts? What will be the procedure for this? What is the procedure for that? All of this is determined by the Indian law, because procedural law is lex fori. I hope you get the point. Article 21 of the Constitution is perhaps the most widely interpreted provision in all of Indian law. It makes a mention of this little phrase, procedure established by law. Article 21 reads as, no person shall be deprived of his right to life or personal liberty except by the procedure established by law. So is this referring to procedural law or substantive law? Because you see the word procedure here. Don't get confused. The meaning of procedure established by law just means that a law that has been enacted by an authority which is competent, right? So don't get confused. This has nothing to do with procedure and substance. Article 21 and the procedure established by law relates to both substantive and procedural law. The procedure established by law here basically refers to a law that has been made and enacted by a competent authority. That's it. Perhaps we might agree that the purpose of law is to dispense justice, is to serve justice. Now, what is justice? That perhaps is told to us through the substantive law. What is justice is told to us through the substantive law. And how do you go about dispensing the justice? What is the procedure? What is the manner? That is what we understand through the laws of procedure. As you might understand, the substantive part of the law appears to be more important. In other words, let us say this is where you start and this is what your destination is. Okay? The procedure or the path has been given keeping in mind the destination, right? So your target, the goal is substantive justice, right? So when we say substantive justice, it means that as far as the rights and liabilities are concerned, there has been justice. Okay? So as you can see, substantive justice appears to be the goal of law, because ultimately we need to achieve justice. Then what is the significance of procedure? Let's have a look. What you see on your screen here is a very foundational canon of law and a very important principle of justice. Let me give you an example. Let us say there are two parties. Let us say they have a land dispute. So obviously A says the land is mine, B also says the land is mine. They have a dispute and they decide to knock the doors of the court, and here they are before the judge. Okay, here's the judge who is here. Now, let us say what the judge does is that the judge has a good look at A. He looks at A closely, then he looks at B closely from his table. Okay, takes 10 minutes and then decides that the land belongs to A. So he says, okay, A, the land belongs to you. This was the first way in which he settled the matter. Let us say he approaches it in a different way. Let us say what he does now is that he asks A, okay, A, give me your documents, get your witnesses. He does the same with B, show me your documents, get your evidence. Perhaps he goes for a new hearing, okay, and then after 2 hearings, again, he arrives at the same conclusion. He says, okay, the land belongs to A, which means both in the first case as well as in the second case, the result was the same, which means the ends were the same. However, what was different was the means. And as you can see, in the first case where he adopted a method, a procedure that did not appear fair, you feel that justice has not been done, whereas justice maybe was done. Right? So as you can see, the procedure also bears a lot of significance in the belief that there has been justice. So although it might appear that the procedure is not important, the procedure does have a very crucial role to play in the dispensation of justice. We just spoke about how important it was for us to follow the rules, right? And now I will play the devil's advocate and talk about a certain kind of strike, which is called the work to rule strike. So what is a strike? Well, a strike is a method whereby perhaps a trade union of some laborers shows their resentment. Okay, so let us say there's this trade union that is dissatisfied with something which its employers are doing, and it wants to now hold a strike. There are many ways of going on strike. You can hold a dharna, you can stop going for work, which is cessation of work, or you can go to the workplace and you can go slow. It's a type of strike, go slow. There's another type of strike which is to tools down. It's like you go in and you keep your tools down. So there are various ways of going on strike and not cooperate with your employer. You might be fascinated to know that work to rule is also a kind of strike. You know what they do in this? They very strictly follow the rules. In this strike, they very strictly follow the rules. And you know what that does? That makes the process very slow. It's very interesting to note that when you follow the rules very closely, that also causes problems. Perhaps you get an idea of what I'm trying to tell you. That let us say you started following the rules of procedure too strictly. You became too pedantic about following the rules of procedure. You might end up not achieving the target. You might end up not achieving the ends. You might not get substantive justice. I'll now show you a few things that the Supreme Court has to say about this. Each one of these quotes that I show you have been taken from judgments of the Supreme Court. Have a look at this first line. It says that substantive justice must prevail over procedural or technical justice. Which means, let us say, there happens to be a point sometime where there is a clash between substance and procedure. There's a clash. In such a case, who wins? Who should prevail? The Supreme Court has said that substance must prevail over procedural or technical justice, right? There are some more ways of putting this, and I just thought I'd place them before you. Have a look at what the Supreme Court had to say. So it says that if you did not follow a procedural law, that's not a major lapse, but to not follow a substantive law is a major lapse. Okay. Likewise, procedure is there to serve the ends of justice and not vice versa. Procedure is meant to facilitate the administration of justice and not to defeat the same. So let us say someone strictly follows procedural law and ends up with something which is not really the whole complete justice. What do? We'll have a look. We look at a Privy Council case, a case of 1955, which talks about a scenario in which strict application of the procedural law appears to lead to a travesty of substantive justice, which means that you're following the procedural law, but that appears to lead to a denial of justice. What is it that can be done in such a case? In such a scenario, it says that the judge has the discretionary power to disallow evidence even if it does not comply with the rules of evidence, which means the judge has discretion to depart from the rules of procedure. So let us say the Indian Evidence Act says that you must go in this way, but when you go in this way, you miss the target because the target was to go here and you end up going here. So now the judge has the discretion to not follow that path and then take a different path so that you reach your destination. Okay. So in case it is found that the substantive law or the substantive justice is not being served by strict adherence to the procedural law, the procedural law can be departed from. So we've just seen that it might not always be appropriate for us to strictly follow the rules of procedure, which means that we might have to sometimes deviate from that, depart from that, and when we do so, it could either be an irregularity or it could be an illegality. Okay. Now what is the difference between these two words? Let me give you an example. Let us say there's this boy who does not behave himself. This boy of the age, say, let's say he's 12 years old. He doesn't behave himself. You can use two kinds of adjectives for him. On the one hand, you could call him a bad boy, or you could call him a brat. On the other, you could call him naughty. You see, neither of these is a compliment, but naughty looks like a milder word. It looks like someone who can be reformed. It looks like someone who can be corrected. It looks like something which is not so important. Whereas when you see brat, it appears to be a more serious word, right? So basically, if I were to draw that parallel, when you're calling something bad, that's an illegality. And when something is only naughty, it's an irregularity. To sum up our discussion on illegalities and irregularities, we understand that both illegalities as well as irregularities are a deviation from the prescribed path. So let us say this is the path that has been prescribed by the procedural law, and this is the destination. Let us say this is the destination, right? So we know that this is where you have to finally reach. Now, it is possible that one has deviated from this route. So let me just say you deviated from the prescribed path. Instead of going straight, you perhaps went like this. Now, either this deviant path could go and land up in the correct place, in the correct destination, or this deviant path could perhaps go somewhere else. Okay. So, a deviation that does not occasion the failure of justice is an irregularity. An irregularity is a deviation that does not occasion the failure of justice. What that means is that it means that despite not having followed the path, let us say you took a different route. The route that was taken was perhaps you started from here, you went somewhere else, but finally you landed up in the right place. That means there was no failure of justice. In such a scenario, this may be an irregularity. However, an irregularity that cannot be cured is an illegality. So what is an illegality? An illegality is an incurable irregularity. Let's think of it like this. So we have our summary. So we know that an irregularity is a deviation that does not result in the failure of justice, does not result in the miscarriage of justice, and an illegality is an irregularity that cannot be cured. In other words, an incurable irregularity is an illegality. I have discussed this in detail in the video that you can see here by clicking the I button. I have discussed this in detail, the entire provisions relating to irregularities and illegalities, and as to how this is dealt with in the CPC, CRPC as well as the law of evidence. For the time being, we will end this lesson. Thank you for your patience.